Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live broadcast. Last week I skipped it. I wasn't feeling the best. So here I am, a little bit early, but I'm going to go through and get started again at least. At least I hope so. Hopefully a few people will watch. Hopefully someone will say, hey, that's right. Without further ado, and I've added about 37 new points to my numbered list. So starting off with number 215, the 78% solution on the cost of living allowance issue allegedly resolved in the Manuge Federal Court 2012 case. Now what that was about is that they said they found another issue during the resolution of the case, and they said that the cost of living allowance should have been put on the entire amount of the service income support insurance plan, not the net amount after clawback. But McInnes-Cooper allowed the government of Canada to get away with only paying 78% of the damages. Now, I spoke to Dennis personally about this before, he got too stressed out by all the stuff I was telling him, and he unfriended me on Facebook. But I spoke personally to him about this, and I said, Dennis, why did you accept 78% when you should have got more, not less? Well, he said, McInnes-Cooper told me you don't always get what you ask for when you sue someone. That might be true in a commercial dispute where you might not win. But here we had disabled veterans who were hurt in service, and they were offered 78 cents on the dollar to resolve the problem. That's insane. They should have got maybe 150% because of the circumstances. Sure, if you go to court, you might lose. But they had admitted that they did it wrong, because that's why it was resolved by agreement. Instead of the court ordering a solution, McInnes-Cooper accepted 78% instead of 100%. That sets a bad precedent. If you have a weak case, maybe accepting less than what you could have got if you had kept fighting might be okay. But this is the inflation adjustment that they were doing wrong, and they allowed them to profit from their illegality. There's supposed to be a principle here that no one should profit from doing something wrong. That's just the way society is supposed to run. Okay, point number 216. True compensation for injury, which I put in brackets, a capital payment to replace a capital loss, in brackets, cannot ever be taxed as income because the money is not legally income. Now see, a lot of people falsely believe that if you receive a sum of money, you are receiving income. Well, in the fifth or sixth point that I'm going to bring up tonight, I'll be discussing the case in the Manuge case again about how that's wrong. But there are several according to the Income Tax Act, several sources of money that you can receive that you won't be taxed on. One is if you get a windfall. So you're walking along, you find $1 million. You didn't earn it. You didn't win it. You just found it. And that's called a windfall, and that is not subject to taxes. Now, I can't help interject because I'm somewhat cynical. How is anybody ever going to know that you found $1 million? So really, that's kind of a rule that makes sense because, well, you'd have to be stupid to report it to the government anyway. It's none of their fucking business. That's just my 2 cents. But there's other ones like lotteries. If you play the lottery and you win, you get money. But you don't get income because you risked some money to have a chance to win that money. And there are rules about you can't get income from gambling. I mean, it's not income. You took a chance. You might have lost your money, but instead you won. You don't have to declare that in taxes. Now, the U.S. has a different perspective on that, and that's their business with their income, the Internal Revenue Service, the IRS. But in Canada, we follow the same rules the British do, and basically there are certain things that cannot be taxed, because they're not income legally. Damages are not income. Damages replace what you lost. So if you get hurt, somebody injured you, they have to repay under the law. If you sue them, the money you get is not income from an employer that you went to work for voluntarily by mutual consent. You get money because the person injured you, and to balance the scales, they have to give you damages, which is legally capital, not income. It might be a bit different if they tried to tax it as capital, but they're trying to tax something that is legally capital as income, which is stupid. Shouldn't happen. If, they want to do it by the book, you want to tax damages, you fill your boots and you try to write the law around capital, not income. Okay. Next point is sort of similar. Income or property, point number 217. The key question, I think, for a lot of the stuff that we have, and I put in after the comma, Clarke Supreme Court of Canada, 1990. Again, as I stated in the previous point, some people, or most people, maybe nearly all people, believe if you get money, it's income. Well, if you served in the Canadian Forces, as an example, you earned all of your income for your service. But all of the service income is not given to you at the time you earn it. So they put some in the bank. That's your contribution towards the future. Now that is savings. The government has voluntarily started a trust system where they bank your money that you earned for the years you served, and they agree to give it to you after your service. Now, in the Clarke Supreme Court of Canada, the 1990 case, it was a divorce case, and the person who was, had the pension, in this case, the man, he wanted it to be called property, and the ex wanted it to be called income. Now, obviously, and I'm not going to get into exactly why that was the case, but each had their own preference that it was considered income or property. Now, the Nova Scotia Court of Appeal agreed with the ex and said it was income. Then, the guy, he went to the next level of appeal, the highest level of court in Canada, and it came up for review, and they overturned the Nova Scotia Court of Appeal's decision that it was income, and they said, I'm sorry, it's property. Now think about it. It has to be property because the soldier earned the money when he was in service. And he put the money away, the government banked it, he had savings, and therefore it had to be property. There shouldn't have been any question about it being property. I don't know what all this hullabaloo is about. Now, like my Member of Parliament staff said to me when, hey Matt, if it's not income and it's property, how come the government taxes it as income? Now, I shouldn't have to explain to a sitting Member of Parliament, their staff, about the fact that the government chose to make pensions attractive in the 50s. And they decided to not tax money you didn't get until you actually took it out of the bank. So while it's being contributed, while it's vested, meaning locked in, and until you take it out, it isn't to be taxed. But then, as the counterbalance, the quid pro quo, when you take it out, it has to be taxed because it should have been taxed at the beginning. That's their point, and I agree, more or less. But they would argue that you're going to have a lower tax rate because you have less income when you get a pension, so it's to your benefit. Now, the reason I would disagree with that is I analyzed my Canada Pension Plan disability, my Canada Pension Plan contributions, and I looked at how much taxes I would have paid if I had paid taxes on it when I earned my salary. And then I looked at how much taxes I would have had to pay when I drew out the Canada Pension Plan disability, And lo and behold, after 3 years, the government makes money in my case. So the plan that you would pay less taxes because you have a lower tax bracket isn't true in my case. Now, is it true overall for everybody? I don't know. So their argument that they only defer taxes until the future, well, it could be false. Maybe they're making a profit. Maybe they're making more taxes when you withdraw the money from the bank than when you left it in the bank. Now, the idiots at Finance Canada often put into their tax expenditure reports that they lose this much money because they don't tax it on contribution, or they don't tax it when it's invested, and they only tax it when it's being withdrawn. And they seem to have forget the public policy reason that this was brought in the 1950s. Now, they shouldn't be missing that point. They shouldn't bring up, this is a tax expenditure, which to review, that is a report put out by Finance Canada every year, and they list off all the different things that they could have collected taxes on, but they didn't. So because of that, they lost taxes, and they call it an expenditure. Now, I think it's a stupid name, personally, because to me, an expenditure is when you have money in the bank and you spend it. To me, that's an expenditure, not looking at the foregone tax revenue because you chose a certain policy and then proceeded to go along with that policy. You can't cry later about that spilt milk because you chose to follow that governmental policy. It just seems to be a bullshit system, but the whole thing is based, that's what it's all based on, so you can't totally throw it out, I guess. Anyway, point number 218, de facto control of something. And then I said Manuge Federal Court 2012, and Manulife being a stranger, not in control. Now, what I'm getting at there is that the government is, and this is one of my key points to everything I do, the government is lying about Manulife insuring the Service Income Support Insurance Plan Policy 901-102. Now, how do I know that? Well, I know that the government got sued in the Manuge and the Butte estate cases. Now, there was 2 concurrent cases going on at the same time about the Pension Act pension being clawed back from the RCMP under the Great West Life policy and under the Manulife policy for the military. Now, neither Great West Life nor Manulife ever took a step into court. The members of the RCMP and the members of the Canadian Forces sued the government. Now, if you're getting sued for something you didn't do, at the very first day of the court, you'd stand up and you'd say, I'm sorry, I don't know why I'm here. This is not my business. This is Manulife's lawsuit. Never happened, because everybody knows Manulife and Great West Life only act as an agent in these 2 policies, at least, for the Government of Canada. So the Government of Canada had to take the hit on the chin. But you see, they haven't ever fixed it after and said publicly that this is an administrative services only policy where we hired somebody else to administer our insurance plan. And we are the underwriter, not Manulife. They've never stated that publicly, even though McInnes Cooper had in the list of allegations that it was an administrative service only policy. Now, there must be some kind of reason why the government doesn't want to admit it, and I have my thoughts on that. One of them, if not the main one, is the government wants to get away with ignoring the law that the government passed. So, for example, in the Université de Laval Federal Court of Appeal 2002 case and the National Bank of Canada 2003 Federal Court of Appeal case, CRA took the employers to court, and they said, you're not deducting the employment insurance premiums for this income you're paying to these disabled people. Now, CRA didn't care about the fact that the payment was literally made by the insurance company. They said these are administrative services only policies where the actual employer is the source of the money, the source of the income. And you know, under the Employment Insurance Act, they said, you are required to take out the premiums. So that costs whoever is the employer money. So if SCC and Great-West Life and Industrial Alliance for the Public Service Management Insurance Plan and Sun Life for the unionized employees in the public service, if they operated under those rules that CRA enforced in a court of law against those other employers, then their expenses would be higher because the government would have to put 140% for every dollar they took off. They'd have to put $1.40 with it, and to remit $2.40 to, which is ironic, Canada Revenue Agency. So the dollar they take off of your payment, they don't care about that because, well, that's just coming off what they got to pay you anyway. But the $1.40 that they have to put with it, that'll cost them a fortune. Because not only are they having to match it, they got to put in 40% more than just simple matching. So that's one reason that they're doing this shit. The other one is kind of the pension plan contributions. So because the money is, according to CRA, coming from the source of employment or the former source of employment, they say that Canada pension plan contributions should be deducted as well. So again, the government wouldn't care if it was only your money coming out. If it was only the, say, dollar coming out of your payment, they wouldn't care. They'd just deduct it and send it in. But according to the Canada Pension Plan Act, you had to put $1 with it when you're the employer, so you had to send in 2. When the employee pays 1, the employer has to pay another. See how that would cost them money? So ironically, the employee earned both. Perry versus Cleaver, 1969. Service has value. The fact that it's paid by the employer doesn't matter. It's made on the employee's behalf. Something they all ignore. Okay, next one. 219. Long-term disability reapplications. Either an annual medical or a questionnaire amount to a new application for a benefit already owned. Now let me break that down for you, why I used the particular words I used. Insurance is a property, so you pay the premium against the risk that may or may not happen. If the risk happens and you then get long-term disability, well, you're getting payments because you bought it. It's your property. Insurance is property. But in order to save money, what the insurance company, acting on behalf of the Government of Canada for the 4 LTD programs I'm talking about, the SCC, Great-West Life, the Industrial Alliance, and the Sun Life policies, what they do is they make you apply every year after the 2 years that they only look at your own occupation. So they have an own occupation, they leave you alone for 2 years. After that, they use an any occupation rule, which is similar to but tougher than the Canada Pension Plan Disability Rule. So, the 3rd year, they make you apply or go to the doctor and get a new medical. Why? You shouldn't have to do that. It's your property. They approved you at the 24-month mark until you turn age 65. But they reopened the issue, reopened the wound, by making you go to the doctor in the case of the Manulife policy. For the Sun Life policy, they send you a form that you only have to sign, but again, why do they make you do it when they approved you past 24 months till you turn age 65? Why are they bringing it up again? Well, obviously they're hoping that you'll forget, fight with them or something, and then they'll be able to save money when you fight with them, like what I did. Okay? I told Manulife to fuck straight off. After they contacted me 6 months after I did my last medical, I first started going along with them, and then I said, hang on. If it's every year, if it's an annual medical, why are you calling me 6 months ahead? Then I started thinking about, well, you know, you're giving me a lot of trouble about Canada Pension Plan, and you're taking into account, and Sun Life's taking into account. Why are you making me go get a medical when you know I'm still getting the Canada Pension Plan Disability, so you know I'm still too disabled to work? Why you make me do it? Then I said, well, you know what? I'm not doing it. You should use the same definitions as the rest of the government. You know I'm getting Canada Pension Plan. You know I'm getting a Disablement Public Service Pension. You know I'm getting a Disablement Canadian Forces Reserve Force pension. Well, enough's enough. I'm not going in to get poked and prodded for you. Now, I didn't give it up entirely. I went to my member of parliament and I explained to them that they needed to fix this problem. So I went to the top. At the time, he was the Minister of Veterans Affairs, Seamus O'Regan was, and he was the Associate Minister of National Defense. So, seeing that SISIP is a National Defense public long-term disability insurance, I went over their fucking heads. Never got me nowhere because they want to save money. They want to save money more than to do it right. Now, ironically, they would save money if they did it the way I talked about it. Because why should everybody have to have our go to the doctor, waste healthcare doctors, my time, the doctor's time, and then the paperwork gets sent in to Manulife, and then they probably charge the government? Why should that always happen when basically it's a waste of time and effort? It's similar to, even though it never got me anywhere, the 2016 90% thing with the earnings loss benefit. People on SISIP should have gotten it automatically, and they shouldn't have had to apply for the additional earnings loss benefit from Veterans Affairs, because why should it go through a process where you might get denied when basically it is designed the now called income replacement benefit, but at the time it was designed, it was called the earnings loss benefit. Now, Veterans Affairs earnings loss benefit was set at 75% and SISIP was 75%, so there was no extra payment. But when the government, in its infinite wisdom, made the payment 90% for the income replacement benefit, that resulted in a change in the system. And then, because the SISIP system pays 75%, well, then Veterans Affairs had to make another payment. But the way they designed it was they made people apply so they could have veto rights, essentially. What they should have done was make the payment automatically. Now, you might say, well, they're two different programs. Well, I would refer you to the program arrangement between the Department of National Defense, SISIP Financial Services, and the Department of Veterans Affairs, signed in 2006, updated in 2012, and in section 3.1.2, they state that on a medical release, Service Income Support Insurance Plan Financial Services will be the first provider of income replacement. So according to them, these systems are intertwined. Okay? So the first payment is made by the Department of National Defense Long-Term Disability Insurance, and then VAC only pays when it has to. Now, when the insurances, because they're both insurances, when they were both 75%, that resulted in the government screwing over veterans by abusing their non-indemnity and contributory long-term disability insurance that they bought while they were in service. The Service Income Support Insurance Plan is a bought program. Commercial. If you had that you already bought and paid for, then the government refused to pay you a cent of compensation for your injury. Now that's fucking crazy. It's totally against the rules. You are not supposed to take someone's property, because insurance is property, and then reduce their compensation for injury. You're not supposed to do that. It's illegal under the common law. Okay. Last one. I'm getting a bit drawn out. 220. The Stitzinger Ontario Superior Court case quoted by the Manuge case in 2012. Now, I haven't been very diligent these days going into my observation post, which I designed as a searchable database. But tonight, I went in, I searched Stitzinger, Stitzinger, and lo and behold, from 2016, here's what I was talking about, okay? So this came up in the Manuge case, and I'm going to read it off for you. You can quote it off and look it up in my group exactly like I'm doing. Now, they said, I have a reservation about this. I'll probably stop and put in a bit of editorial every now and then. Periodic payment of damages do not constitute income within the meaning of the policy. Then I put in brackets because when I did all this stuff, I put my own, take on it. Periodic payment of damages are still damages. SISIP LTD payments are payments for damages, damage to earning capacity based on the policy. I don't know if I'd put it that way anymore. Anyway, income, the court case said, is the produce of an existing ability or an asset. Now that's entirely true. You see, the way they look at it, they look at your body like a tree. Now, if you put your body to work, if you rent it out to somebody, it produces fruit, which is the income. But your capital, your body is capital, and only the extra stuff that you work at, that is income. That's their analogy. Damages, on the other hand, remedy the loss of an ability or an asset. Now, here was my quote back in 2016 when I posted this on the 16th of April. I said, SISIP remedies the loss of ability, but what makes it non-indemnity is the inability to quantify the loss. Now, I'm still right, because what it is SISIP doesn't pay an indemnity, which is compensation. SISIP pays according to a formula in a policy. Now, they chose 65%, I think, 60 maybe at the beginning, and they added 5% for the first 2 children and one extra 5% for the spouse, and you could get a maximum of 75% at the beginning in 1969. Somewhere along the way, I could look it up if I cared, they made it just a straight 75%. They wiped out the fact that we worried about children or a wife, and then they made it 75%. But the 75% is a formula in a contract that doesn't actually take into account any loss, period. They don't go into any depth to try to figure out what you lost. It's, what is your salary? Here is 75% of it. In other circumstances, an annuity contract may well be regarded as an investment, and payments made from such an investment will be income. However, in the circumstance of this case, the annuity was an integral part of the judgment. It was the means of providing damages paid periodically. Now, I don't agree with what I was thinking back then, or maybe I discovered more stuff since. I said SISIP is a means of providing damages. But that's not true, because it's not an indemnity. So I'll have to go and change this now that I'm aware of it. Don't like mistakes. Since the judgment is not an investment, neither an annuity is an annuity, which is part of it. So basically, if you put the money you get from a case that you won, and you put it into an annuity contract, and then you got an income from it, they're saying it stems from the same source. That even though you're getting periodic payments, it's still periodic payment of damages. They're not converting it from capital to income. And the fact that such damage payments are periodic, like income, does not change the legal character. They remain damages. And I put in brackets, great point. Because it's true. It is a perfectly good point. And I believe that's why they put into the Income Tax Act in Section 61F that they put it has to be payments that are periodic in order to attract taxes. So if you get a lump sum, like the people in the Manuge case, you got a lump sum, not a periodic payment. That isn't income, according to the Income Tax Act. Because the Income Tax Act has the word periodic in there, like this case. Income is periodic. Long-term disability payments should be periodic, but because of the Pension Act being taken into account, many people didn't get a payment. And then when they did get a payment, it was in a lump sum. So then a lot of people, including the CRA and the government, will say, well, you know, it should have been periodic, so therefore it has to be taxed. Well, I'm sorry, the law is not that flexible. It's periodic or it's not periodic. You can't have it both ways. If you have it both ways, they could have left the word periodic out of the Income Tax Act. Then they could have taxed it whether it was periodic or not periodic. But they didn't. They put that word in there for a reason. Now, it's a stupid reason. They wanted to make it linked to income because income is periodic, and they wanted to make it sort of like it, so they wanted to justify themselves. Now, that's my 2 cents. They never said that. You can read into it. Okay, I'll carry on, but I think this quote was too long. I shouldn't have probably read it all, but I'll say, while the defendant argued that the principle of subrogation, now, subrogation is putting yourself in the shoes of someone else. So if you were hit by a car and you sued the person who did it, then the people would get the right to sue the person who hurt them to try to transfer the costs. It's related to clawbacks too, because subrogation is a creature of equity, and equity is something that, you know, they base clawbacks on. So if I owed you 2 and you owe me 1, you wouldn't give me 2 and I give you 1. You just pay the difference. That's called equity. You know, it's about fairness. And does not apply. It's not shown that the plaintiff have been fully compensated for their losses. Now, here's the reason why that's important, okay? When a person is injured by someone else and you go to court to get damages, you are entitled in the law to get up to 100% of your losses. You're not legally allowed to get 1 cent more than what you lost, according to the principle of compensation. Now, when they want the claw back, then they have to show that you received more than you should have got. When that happens, they can claim the excess. See? But the problem I have with that is the judge, in a court case, in a lawsuit, they have to take the evidence into account and decide what to bring into account. So if they, during the case, says that this is how much money you should get in damages, then that is what you are legally entitled to get. Now, how are you going to get more than what the judgment called for? Okay? They are legally required to pay exactly what the judge said. So how can you get more? How can the overcompensation issue ever arise? It can't. It fucking can't. But what they've done to, again, I mean, I'm not a lawyer, but I read a lot. Read a lot of cases, read a lot of stuff. What they're trying to say is, to bring it into their bailiwick, is they're trying to say that, say, the SCC policy is compensation. So therefore, we should be able to take that into account and reduce the amount of damages. Now, that was thrown out in 1875 in the Bradburn versus Great Western Railway. Insurance, being non-indemnity and contributory, cannot be taken into account to reduce someone's compensation, which is an indemnity. Now, your head's probably swimming now because my head's swimming a bit. But basically, they had to be alike. So if you're getting apples, which is the compensation, and SCC is an orange, you can't take the orange into account. Now, Manulife took, and the government took, it the opposite way. Because they couldn't use the Pension Act, use SCC to reduce the Pension Act payment, they decided to reverse it and take the pension into account, which is entirely absurd. A non-indemnity payment cannot legally take into account an indemnity payment. Now, to fix that, the government put into law Section 30 of the Pension Act. And they said that every creditor can piss in the wind, basically. I'm paraphrasing, but that's what they said. Anybody who's getting a payment from Veterans Affairs to compensate them for their injury under the Pension Act, if the creditor sent a bill to Veterans Affairs Canada, they'd throw it in the garbage or send them a polite fuck-off letter. But the idiots, or the crooks, the sleevings, the slime bags, they decided, well, you know what, we got an opportunity here. If Veterans Affairs is not saving because of the SCC payment, then, well, we'll take the Pension Act payment into account and we'll put it into contract. Now, first thing I would have said if I was involved in this Manuge case, when they said they had the right to take it into account under the SCC contract, I'd have said, hang on now, can you explain to me when and where the Canadian Forces members sat down and negotiated that term to put it into the contract? They're not going to be able to because it was never done. You see, the terms of a contract has to be a meeting of the minds. So when you sit down with somebody and you want to negotiate a contract, you talk it over and then you put your John Henry on it to show that you agreed to it. But the Pension Act, being taken into account to reduce the SCC long-term disability payment, cannot legally have been a meeting of the minds because the Pension Act Section 30 forbids it. So even if the veteran is not aware of the legislative immunity, the legislative prohibition, everybody is supposed to know the law. So therefore, the person who wrote it into the law, they knew it was illegal, and they tried to get away with it. McInnes Cooper was right when they put into the statement of allegations that the government broke Section 30 of the Pension Act. They were right as rain. But nobody likes to admit when the government breaks the law that it wrote. So they came up with a creative solution, and they said they were going to hear the case as a contract dispute. Now that goes back to the point I was making. How can you have a contract dispute be litigated when there was no formation of a contract? My understanding of a contract's formation is that there are 3 conditions: offer, acceptance, and consideration. Offer and acceptance are self-explanatory. Give and take. You know, you say, I'll give you this, and then you say, no, what about that? Or something like that. The consideration is money or something valuable. So in a contract of employment, you agree to give the employer time, and they agree to give you money. But there was none of that in the SCC policy. It is not a contract. So therefore, how could it have been heard as a contract dispute? It couldn't legally. But unfortunately, the government seems to have gotten away with it. We need this all to get exposed and get fixed. That's what I keep doing these for. We need to say, A, there is no real contract between the government and the soldier on the long-term disability program. Now, if there's no contract, then how can they justify taking account of the pension plan disability or the Canadian Forces superannuation into account? The only way they could do that is if the government didn't put legislative prohibitions in place, like it did in the Canadian Forces Superannuation Act, Section 83, and the Canada Pension Plan Act, Section 65. Add to that the Financial Administration Act, Section 67, and you have 3 laws being broken for those 2 pensions. Why do they even pretend to care about protecting the property, which pensions being property? Those laws are meant to protect your property that the government is holding. So I could see a lawsuit based on the breach of fiduciary duty. The government holding the person's money is supposed to look after it as if it's theirs, and they are supposed to make sure that it doesn't get screwed up, that nothing happens untoward. Now, they know that the Public Service Superannuation Act is being taken out of Sun Life and that the Canadian Forces Superannuation Act is being taken into account for the SCC policy, but they don't do anything to enforce Section 83 of the Canadian Forces Superannuation Act or Section 10, brackets 10 of the Public Service Superannuation Act. Basically, they're looking the other way, willful blindness. And I was thinking about doing a column or something on silent witness, because that's what they are. They witness it, but they're silent about it, instead of saying, hang on, we put those laws in place for a reason. A good public policy reason is to protect the money of the pensioner so that creditors, nobody can touch it. Now, why did they do that? Last point, and then I'm going to shut up. Forget about this stuff for a while. They're trying to help themselves. If you had a creditor, I don't care who it is, Ford, Chevrolet, the government of Canada, you have someone who is owed a debt. Now, if they went to court and got that debt certified and then served the certification of judgment to the pension people, well, then the pension is supposed to give you money to survive on after you don't have any more service left in you. You've retired. In order to live, you're going to go knock on the welfare department's door, and you're going to say, look, I had a pension, but because I defaulted on my car payments, they went and got a judgment. They sent it to the pension office, and the pension office diverted my payments to satisfy the debt that the court imposed. So because I have no money to live on, them son of a bitches left me with nothing, I'm going to say, we live in a civilized country. I'm going to put my hand out and said, what are you going to do for me, government? You have to support me now because they took away my property. So basically what the government is doing is protecting itself. When it made those laws, it's protecting itself from higher taxes due to increased welfare. Now, I didn't read that anywhere. That's a conclusion that I came to. But I think I'm right. I don't see how you could justify any of those laws, like you can't touch my pension, because then someone would say, those pension laws, that ain't fair. That's arbitrary. The government's not supposed to make arbitrary law. And then they'd take it to court and it will be struck down because there was no link to rationality. The government can't just make laws because it feels like it. It has to have a reason. That's why those protections are in the Pension Act and the Canadian Forces and the RCMP and the Public Service Superannuation Acts. But if you ask them, no one probably remembers why it's there. And then they'll argue it's an interpretation, that You know, we don't actually take it. We don't take the money. We don't get a judgment and go to court and then intercept that money. We merely take it into account. Now, I'm getting into another broadcast because I got this information put there in another point. But basically, when they ask you for information about, say, your Canadian Forces pension or the Canada Pension Plan or the Service Income Support Insurance Plan, you ought to have the right to privacy. They shouldn't ask you for information that they can't do anything with. Because under provincial pension, long-term disability insurance stuff law, insurance is not allowed to be intercepted. So that's a law that, again, is supposed to protect the taxpayers against welfare, right? Because if creditors went and took someone's insurance, which you're supposed to live on, then the person would knock on the door, get their welfare, and then taxes would go up for everybody else. So the insurance companies are making money, and the government, federal government, is making money by abusing, you know, they're ignoring the fact that laws bind our hands. So anyway, what do we do about it? I keep talking about it. Hopefully people will listen. Hopefully people will say, geez, you know, what he's saying makes a bit of sense. Because if I thought I was going to keep barking at the moon, you know, telling all people, like, I never thought any of this would happen. When I first went public in 2014, I thought, after I was on the radio, that the public would go crazy and it would end. But they have a very large financial interest and they don't want to get a black eye because they don't want to admit that they've been doing it wrong for 40 or 50 years. All of this stuff is not new. They have been successfully avoiding justice for a long, long time. Anyway, I would like to thank, seems like a fair number more than usual might have been watching. Thanks for watching, and I'll try to bring you some more stuff. I'm actually thinking about doing something new. To get out of my comfort zone, because I'm not doing much on Facebook no more, I'm thinking about trying to come up with some ideas, like I called them simple fixes a while ago. So I'll put out the problem that I discovered, you know, reported on, and then I'll give you a little excerpt of what we should do about it. How could they fix this? Quick example, Canadian Forces Superannuation Act, Section 83, if they enforced it, would end Veterans Affairs and the Department of National Defence's clawbacks under the SISIP policy and the income replacement benefit. But they have to be forced into it because, well, they're not going to stop what they're doing it, well, in the case of the earnings loss benefit, income replacement benefit, since 2006. In the case of SISIP, possibly since 1969. So they have all of this baggage that they've been ignoring, you know, the protection under the law, and they seem to have people bamboozled about what you put into a contract has to be followed. I think that might be why, and I'm adding time, I know. I think this is why the condition of a benefits agreement comes into play. Before they pay you a cent under the SISIP policy, they get you to sign a condition of benefits agreement. And then you say that if I get anything down the road, like Canadian Forces Pension or Canada Pension Plan, I'll agree to pay you back. Well, go fuck yourself, Manulife. Why should I pay you back about a future event? We'll cross that bridge when we get to it. Should be the attitude. But oh no, they want to make you feel like you're beholden to them, like they're giving you a loan. And then you have a debt that you owe them. So then they get away with it because, well, you have signed the agreement. So because your signature's on it, you have to obey it. Well, if you don't get money or consideration in return for your signature, it's not fucking valid. They don't seem to care about the legalities of contract law. Anyway, I did say I was going to go, and thanks for watching.